December. This is end of December, and Christmas is coming, New Year is coming. Now we ended the year with a very, very important topic, and that topic relates to a review of 2025. Now, the review actually will be encompassing. Of course, we're going to look at construction industry, how construction disputes evolve during the year, and what do we expect next year, basically. And we're going to look at different other aspects in terms of regional approaches to dispute settlement. And for you today, we have a distinguished panel. I will introduce the panel briefly later, but I just want to give you an overview of what we'll be doing today. For the next 1.5 hours, we'll be looking at international arbitration and mediation, a review of 2025, and the outlook for 2026. This is really important for practitioners globally to kind of know what area should they focus on. As an international practitioner, whether you're in arbitration or you're focusing on mediation only, really need to know what are the challenges and what are the opportunities available to you. And you can only learn that from experts from different arbitration centers and individual practitioners across the world. And for today, again, I'm sure for those of you who have been following our activities at the OIC Arbitration Center, we established what they call the Federation of the OIC Arbitration Centers, FOAC, called FOAC, last month. And in principle, the member states, the arbitration centers from some of the member states agreed to set up this body. And the body now is gradually taking shape. We're working on the charter that will be shared with the member states soon. And that body actually will help to kind of enhance cooperation, standardize best practices, and promote excellence across the OIC member states. And we are just trying to kind of provide a platform, and that's our role as the OIC AC, to provide a platform so that we can bring everybody together and we can learn from each other. So this is actually one part, I think I'll say is the major achievement, if you ask me, made this being able to bring out to us, who saying they want to be part of this initiative. And we welcome everybody to be part of this going forward. Now, one thing we'd like to do today is that we'll be getting insights from experts from Iran, from Nigeria, from Uganda, and of course from Malaysia, and from one unique industry, which is the construction industry, because it's always something that I think many practitioners are really grappled with. How do they kind of break into this industry because of the technicalities involved? And that's why we have, someone who will really kind of break down some of the key trends we saw this year and kind of guide us on what we should be expecting next year. Now, having said that, permit me to introduce the panelists we have today. Now, without following any particular order, I'm just gonna, introduce to you Marcus Cato. Marcus Cato actually is a member of the International Court of Arbitration of the OIC Arbitration Center. I know here, he's the managing director at Macom Partnership. Also you have Macom Partnership in Rwanda. He's everywhere. Though he's based in London, he has a lot of projects in Africa. So we are really glad to have him, and he's been very close to us. He represented us recently at the CIFOC meeting in India, and thanks for that. And we were together in Kampala a few months ago at the CIFOC African meeting. So Marcus has been very, very close to us, and he's been involved in many of our initiatives. And we thank him for creating that time to join us today as a member of the International Court of Arbitration. And one thing we try to do, we try to involve at least a member of International Court of Arbitration in most of our events. So we're glad to have him today. And apart from that, he's an engineer, he's a chartered arbitrator, and he actually, is that expert you need when it comes to construction disputes anywhere, any day. He can break it down for you, even though he always says he's not a lawyer, but he's yeah. So we really thank you, Marcus. Thank you for joining us today.
Thank you, Umar. It's an absolute, it's a pleasure. It definitely a pleasure and a privilege to speak with you.
Excellent. Thank you. Now, the next on my list are, again, I'm not following any particular order. It's Zubaida Namugenyi. Zubaida actually is the Chief Executive Officer and co-founder of the Muslim Arbitration and Mediation Center in Uganda. Zubaida, she has an illustrious kind of career working at the Apex Card, basically, and she has a lot of experience. But again, she just decided that no, it's time to have this independent center. And this was what they set up a few years ago. And they're doing very well. And she's been involved in a lot of initiatives there in Uganda and the region. And we're happy to have her with us today. And thank you, Zubaida. If you're hearing us from wherever you are, I know you had issues with connections earlier. Thank you for being with us. Are you there, Zubaida? Okay. You're muted. The audience, they want to hear your voice. Just say hi to them and okay. It seems we cannot hear you clearly yet.
Hello, everyone.
Okay, great.
Good morning.
Good
Good
morning.
afternoon.
Sure.
Good evening from
Good evening.
wherever you're joining us.
Thank you.
Am I being heard?
Yes, yes. Thank you for joining us despite the challenges you're having along the road, and we're happy to have you. Okay, next on my list is Sir Danish Chandran, who is an assistant director at the Asian International Arbitration Center, the AIAC. Danish, it's great to have you, and Danish is representing the AIAC here today. Of course, AIAC is a major regional center for arbitration. Of course, you all know what they call the ALCO, the African Asian Consultative, Council, basically. And, the AIAC is not just an arbitration center, it's an international organization. It has that status of an international organization, basically in Malaysia. And it's supported by the government of Malaysia. And AIC has been at the forefront when it comes to dispute resolution within the region, the ASEAN region. And we thank you, Danish, for your time and for joining us at almost 7:30 p.m. over there in Kuala Lumpur. You're muted, Danish. Okay.
Thank you so much, Doctor. It's an honor to join with all the distinguished panelists, and of course, moderated by none other than you. Privileged to share some of the insights, and looking forward to speak to all of you.
Absolutely, we look forward to kind of listening to your views and on the regional trends, in ASEAN region, basically, what you've seen and what do we expect for 2026. Now, the next on my list basically is Hajia Hawa Osman from the Nigerian Chamber of Commerce Dispute Resolution Center. She is the Registrar General. I always say Registrar General. The General, I actually pronounce it, differently with emphasis. So we're glad to have you today. And of course, she's Solicitor and Advocate of the Supreme Court of Nigeria. She has had an illustrious career, working with the government, the legal aid, and she has introduced a lot of initiatives over there in Nigeria. And we really look forward to learning from her in terms of the trends she has seen this year in 2025, basically within the West African region. I mean, of course, Nigeria is the largest country there, but again, we want to kind of see the trends she's seen there in the West African region, in Nigeria as well, and what we can learn from those trends and the outlook for 2026. What do we hope to see in 2026? And again, the discussion for all of you can actually go into any aspect, whether you want to focus on investor-state disputes, whether you want to focus on international commercial disputes, or even construction disputes Feel free to kind of talk on any trend you've noticed. I am sure the audience will learn a lot from you today. Thank you, Ms. Howard, for joining us.
Thank you very much, Dr. Osini. It's a pleasure to be here. And thank you for the invitation to speak again on this platform. I'm
Thank you.
truly honored to be with the panelists here today. Thank you.
Absolutely. Thank you so much for joining us. Now, last but not the least is my own dear sister. And I'm sorry to use that. I know others will be jealous now, that I use this word, my dear sister here. Dr. Rahima, actually, she's very close to us as well. In fact, we have a special arrangement with her to be our representative there in Iran. And she's been doing an excellent kind of job there in opening the market for us. In fact, we all saw that during the last OIC, ADR days we had in Istanbul, the largest contingent we had came from Iran. And thanks to her efforts. Dr. Rahima is actually the managing partner at JPAD International Law Firm. And I'm told JPAD International Law Firm is the largest international law firm in Iran. And we are really glad to have her to share her experiences, what she has seen in Iran and elsewhere. Of course, sanction is a big issue, it's a big topic. Everybody wants to know how to deal with Iran. So you're going to teach us if we want to enter into kind of contracts, agreements with Iranian partners, how do we go about it? How do we, I won't say circumvent, how do we go about working within and around the sanctions, basically? So thank you so much, Dr. Rahima, for joining us. And I really look forward to, your insights on the topic you'll be presenting on. Dr. Rahima?
Hello, everyone. Thank you so much. Being at this panel is a great pleasure for me and to accompany the OICAC. Always has been the great pleasure for me, and the representation of this great community is always one of the most brilliant thing that I've ever done for me. Thank you, Omar, for sure. You are my dear brother. I'm proud of you. I've always said that.
Thank you. Thank you. I am proud of you too. Yeah. I'm sure others are jealous now. Yeah. Okay, great. Yeah, I just have to add a little bit of humor to to the session, and that's me. So, audience, just pardon my approach today. This is who I am. One thing I would like to say, it's one thing that connects everybody you see, the panelists we have today. It's the Federation of the OIC Arbitration Center. We are all part of that federation. And the good thing is we're all part of the establishment of it. The 6 panelists here today, I'll say 5 plus 1 because I'm also one of you. We're all part of the establishment of the FOAC on the 28th of November, 2025 in Istanbul. We're all here physically and we all agreed in principle among others, So it's really great to be able to do something together today. And I look forward to more initiatives that will bring all of us together. Now, without further ado, I think I would like to proceed with the presentations. Now, I'll like to invite Marcus because, of course, he's my boss here today, being a member of the International Court of Arbitration of the OICAC. I'd like to give you the floor, to kind of present some of the trends you've seen, basically when it comes to the construction industry, the global overview of dispute trends in this industry, what you've seen in 2025, and what you hope to see in terms of the outlook for 2026. Now, for the audience, I think this is really important, particularly the practitioners amongst you. This will actually create opportunities for you to see where do you have to look at for next year. Where are you going to make your next $1 billion US? Yes, it's possible.
Yeah.
Because you're scratching your head, it's possible.
100%.
So this is the essence of having this session. For me, I always look at opportunities. Where are we going to actually make, the next $1 billion? That's what you should be looking at. And this is why we're bringing this panel for you today for free. But again, when you make that $1 billion, please remember us. We are here to share it with you. Marcos, the floor is yours. Take it from there.
Okay, so look, I am known for going straight to the point and being very practical about what I say. And for those of you who want to do more in the dispute resolution field next year, one of the key things that I think you really need to concentrate on, particularly in the construction industry, is making sure that you deal with the problem and even-handedly navigate towards the quickest and most cost-effective way of resolving that particular dispute. If, as a practitioner, you can offer a multi-tier approach that can combine and carve out elements of an arbitration, send elements to mediation, send it to adjudication, or send it to expert resolution. Don't work in a silo. Don't feel that you have to silo off and follow one course. It's all about agility. You've got to remember that you are going to be working for a client, and that client will either be a government or it will be a private company, and speed and cost are hugely important. This is about commerce. This is not about resolving an abstract or abstruse or complex dispute resolution for our own satisfaction. Okay, this is about dispute resolution. And as I said in Istanbul, some of the disputes that we have to move through are very important to the communities and to the governments that we serve. And we are obliged professionally to make sure we resolve these disputes quickly, because a week of a hospital not being open, or a motorway not being open, or an airport, all right, only hurts the communities and the countries that we serve. So it's so important to make sure that we have that at the forefront of our objectives. That's not just me talking, Umar. When I went to the Standing International Forum of the Commercial Courts, which is a membership of 57 countries who discuss and look forward to the challenges that are ahead in terms of the judiciary in those 57 judicial countries, the focus was very much on what can we do to make the judiciary help serve commerce and help serve the projects that move through the dispute resolution process. So they are extraordinarily keen to make sure that there is a strong dispute resolution framework in each of those judiciaries. And in your own judiciaries, people, if you believe that there are improvements that can be made, or observations that you feel are valid because you're all professionals, then it's the time to reach out to your judiciaries, and it's the time to reach out to the Chartered Institute of Arbitrators branches or chapters within your judiciaries, to make sure that what you see on the ground, how can I put it, at the tip of the commercial dispute resolution, what is most effective. And if you don't think that the infrastructure in your judicial is working, then you can do something about it. Because if you're thinking about it, then many more people are thinking about it. And this is the beauty of having organizations such as the OIC. Because the OIC is an open-minded, thought-driven organization that has commercial support for all the organizations, the countries, investor state, but also project-based disputes at their heart. And regularly discussing with your own arbitration centres, with your own professional organisations and your judiciary. It's so very, very much so important to do that. And the other thing as well is it presents you with a different aspect to your professional career, because what you're doing is you're starting to think strategically, which is always a great thing. It's a good thing. So agility, strategic thinking, all right, and making sure that you're discussing these issues with your professional colleagues is really important. In terms of trends, Umar, there are two worrying statements that I heard this year. The first one is in regard to the High Court of Delhi and government projects in Delhi were no longer going to use arbitration in public contracts, public construction contracts. And the thought process is that arbitration is not quite delivering what they need. And this was very much repeated in Nigeria. There is a trend that I've heard from a number of sources, a number of judges, that the confidence in arbitration in Nigeria is starting to reduce, that there is a swing towards litigation, and that is due to two areas. One, it's the amount of time that arbitration takes, and secondly, the cost burden on arbitration is seen to be significant. And to a lesser extent, but it has been said to me on a number of occasions, the reliability of good decisions and awards under those arbitration frameworks need to be improved. So the key thing here, I think, is we have to focus on arbitration, because arbitration works well in the family of adjudication, mediation. If you combine all of those tools together, immediately you have a much more agile approach. And the multi-door courts throughout Africa, and which are being formed now in Ethiopia, but particularly in Nigeria, for instance, offer an extremely good option, so that arbitration itself can be used much more effectively with those other dispute resolution processes. And I know, Umar, that OIC is very keen to make sure that we use every tool within our arsenal in order to address the disputes that we have referred to us, and to encourage parties to be agile, to be open-minded in terms of how the dispute is going to be resolved. So for all of the arbitrators out there and the mediators, I believe that you will see in the next year a much more open conversation to combine all of those dispute resolution processes, even under the same dispute. And we shouldn't be afraid of carving those disputes out. I've recently been discussing with a couple of judiciaries in Ethiopia, Uganda, but also in Rwanda, the opening up and the flexibility of being able to carve out litigations, send technical elements out to arbitration, send other elements out to mediation, and they are now very keen to change their procedural rules in order for that to occur. So I think flexibility, agility, arbitrators and mediators and adjudicators thinking on a more strategic level, thinking of your final user, the people and the communities that we serve, the businesses that we serve. I think if we focus on that, I think we'll have an extremely prosperous year, but I think our customers will see the benefits of those changes if we can make those changes. Is that okay, Umar?
Yeah, I mean that's perfect. I mean, I was just thinking of something while you were speaking. What do you think about the trends for 2026 in terms of the outlook relating to the use of arbitration for resolving disputes relating to procurement contracts of governments? Because I mean, it's really, disturbing to see some of the trends we're getting in some of the, the countries you mentioned, India, Nigeria, and a few others.
Yeah.
So do you think this trend will continue in 2026 going forward? Or there's a need to kind of, introduce some very quick fix to kind of think of how we can, ensure that, cost is
Yeah.
in the, as much as possible. And in terms of agility itself, as you mentioned, I think that's really, really important. And the quality of the awards being drafted and reliability of the process itself. I know there's the aspect of corruption. Of course, that might have affected Nigeria, the PI&D case. Yeah, I know Sir Robin actually was involved in that case.
Yeah,
And
yeah.
I spoke a lot
Yeah.
about it here. So the question here is, do you think this trend will continue? Because I see, you have the Chartered Institute of Arbitrators, you know, training more arbitrators on a yearly basis. You have a lot of fellows being, being appointed from time to time. So how do we proceed from here? If we're training more arbitrators and we're trying to promote arbitration, and
Yeah.
some governments are telling us that we shouldn't use this
Yes.
for certain reasons. So how do we proceed from here? Because 2026 will be a defining year for us.
I think we've got to come out of the silo, to be honest with you, Umar. Arbitration is absolutely necessary for technical disputes, and a good technical arbitrator, and I mean, legal arbitrations can also be technical, obviously, and that's why we use lawyers. But if it has a technical foundation, then far more effective than litigation would be. Technical arbitration is absolutely essential. But the fear, I think, that customers have is the extraordinary timescales and the additional cost that may well be coming forward on the arbitrations. And therefore, we have to find ways as an ADR community to start to try and make sure that we maintain the integrity of the process, but we are also able and willing to use other tools which we know to be more cost effective. I am a keen supporter of shorter form arbitrations, which have very have tight timescales or tighter timescales, so that you don't get arbitrations wandering and extending their timescales. I'm very keen, Umar, that we also start to look at ways in which we can avoid arbitrating around the margins of a dispute, so that what we're doing is we're actually focusing on the dispute itself, and we are reducing the amount of technical challenges that the process moves forward with. So if there are binary decisions that either the contracts or the dispute resolution rules have, if we can ensure that we have some binary decisions or binary ways of resolving those marginal technical points of arbitration, it will start to reduce the costs. Reducing costs, reducing time is so really, really important. And I know that some arbitrations do require that amount of time in order to satisfy the parties that they've had every opportunity of addressing those issues. But we have to, as a dispute resolution industry, right, start to make things much, much more affordable and to start to reduce the bureaucracy. Zubida, I'm a massive fan, as you know, of making mediation as informal, all right, as we possibly can, because it's about resolution, it's about solving issues, solving problems. in my heart of hearts, Umar, what I want to do is I want mediators to be on the end of a phone and ready to pop down over to see the two parties on site for 2 or 3 hours or 4 hours in a construction dispute, or if it's a community dispute. So it should be literally just dialing up somebody who can help with that dispute,
Absolutely.
not to have, well, you know, I'm going to need a summary of your dispute. I'm going to need to have a mediation agreement in place. I'm going to need to have this. I'm going to need to have that, because it formalizes something that I think loses some of its the very essence of mediation, in my view.
Yeah.
So again, more formal mediations are required, but if we can then start to say, well, actually, I don't need a formal mediation. Actually, all right, I can just call up. I can just call up a couple of registered mediators at OIC and see if they can help us out, because I've come into deadlock with the other party and I just need to see a way forward. And I think that sort of approach, all right, is the thing that we actually start to need to look at, to stop weaponizing disputes as well.
Okay, great. I mean, it's quite interesting you mentioned mediation here as part of enhancing the confidence people have in arbitration, when kind of explore the complementary role of mediation. And I think that's really important. And you know, why we really need to fix this going forward, particularly going into 2026, is this, you know, we're having, you know, people now talking about the stay of arbitration to facilitate mediation. You know, you know, we were all talking about stay of proceedings in court so that we can proceed for arbitration. But now people are talking about stay of arbitration so that you can explore mediation. And there are two main articles actually on this point, which, you know, I've read previously, you know, so it's quite interesting to see, you know, how mediation can complement arbitration to enhance, you know, the credibility of the process itself. Yeah.
The other thing as well, Umar, just quickly, because I don't want to, we have been looking at, and
for your final intervention there.
Sorry.
Yeah. Go ahead.
You and I have discussed with the Ethiopian judiciary the potential for court-registered arbitrators helping the judiciary to resolve technical disputes.
Yeah.
I think that's very strong.
Yeah.
I think that's an opportunity. It's out of the box thinking. Okay, we know that it's possible. We know that it can work, and I feel that there's some opportunities there that would be incredible to explore.
Absolutely, yeah. Thank you for that. And if we have some time, we'll come back to you later. I know we have some questions already from the audience. Keep the questions coming. And let me see. I need to kind of fly straight away to Malaysia, far away, Southeast Asia, quite far from where I am today. And I would like to look at how the future of ADR itself can be transformed. Again, we'll be learning from the trends we saw this year and what we hope to see in terms of the outlook for 2026. And I would like to invite Danish to kind of walk us through this very important topic. Thank you. You're muted. Okay.
Thank you very much, Doctor. And thank you for the introduction and flying all the way to Malaysia from there, and also together with the fellow speakers. And I'm very interested to see, whenever it has been mentioned, the next trend that we are looking at. I think you have raised some pertinent questions when you talk about the strategic outlook that we would like to see for, especially with the coming up the next year, especially on 2026 onwards. For ASEAN in specifically, as you know, that Malaysia was holding the chairmanship for 2025, and that is going to be, and of course AIAC being one of the arbitral center, was trying also to equally promote the regional collaboration, and we were trying to position, of course, the Asia as a whole, not forgetting our partners that are coming from various OIC countries as well. So we wanted to show as a global hub for 2026, global hub in ADR. So that was resulted in a very positive signing of a joint statement between all the law ministers, supporting a very big framework of cooperation between all the member states, supporting ADR and strengthening regional collaboration among member states, focusing on ADR arbitration generally. So that is going to be something that need to be further challenge to be for us to work together, not only within the ASEAN member states, but also, as I mentioned earlier, with OIC and beyond. And next year we are set to see Philippines taking the role, and of course there's going to be a further drive for these many aspects of regional legal frameworks integration and also trade dispute resolution that will be happening next year. From the aspects of what we can basically look at from the supply, be that from the supply chain reconfiguration, where how the supply chains towards ASEAN is growing, given the fact of the US, China on the other hand, various aspects of trade tensions, and how we are seeing the arbitration centers in our region mainly are preparing towards influx of sometimes complex disputes, especially for next year. And not forgetting the BRICS influence as well, because there are many discussions regionally is taking place on how especially countries like Malaysia going to be positioned in this in BRICS, and there's many discussions on this going on at the moment, because we may emerge as one of those markets that or choice to facilitate in many aspects for emerging market disputes. So the prospects for next year, be that from the Belt and Road Initiative, or looking at the ASEAN integration, or Islamic finance and Sharia compliance sectors, the technological advancements related matters. And also something that we all should be looking at is all the specialized sector, be that energy, technological and construction and digital economy, where some of these sectors are something that not only us, but some of these arbitral centers are not given lots of focus, which holds a lot of potential in years to come. So that's the area that I would like to touch upon generally, to see what is the prospects we are looking at on 2026, which caught my attention. I think we have to have a multi-pronged approach in entering the 2026, and to see what is happening from the geopolitical aspects, to look at the economical aspects, and also on the regional trades that is happening. And this is gonna be putting various arbitral centers in different footing. Knowing this from the beginning of 2023, we have prepared ourselves. We are trying to embrace many of these challenges, and therefore the AIAC also certainly has also embarked into various form of reforms among ourselves. I will try to take you through the slides that we have prepared, Doctor, and also will focus on some of the aspects that I believe so that I will cover generally. The next. Okay. Here, let me touch upon, this is going to be my brief presentation, be that from the, most of these will fall into the overview that I have just started just now on what is the prospects that we look at. And here, the AIAC, the ADR ecosystem in Malaysia, what is AIAC in focus, and I'll touch a little bit briefly into of our services and the blueprint for 2026, specifically for AIAC. And On AIAC, I think Doctor and many of us are aware the center has been here from 1978, international center in Malaysia soil. The center has been ever since the signing of the host country agreement. AIAC has been the first arbitral center under the auspices of ALCO, and it has taken a long journey with the support and leadership of many people, and also the steadfast support, of course, by the government of Malaysia, and also the ALCO. And today we have come across a very long journey, and this is just a beginning of getting itself to doing a lot more. And ever since it has its core mission has always been supporting both the domestic arbitration and ADR in general. As such, AIAC not only doing arbitration, we also actively involved in adjudication and mediation and domain name disputes, and apart from arbitration, of course. And it has been a very significant year from the time that we changed the name in 2017, later followed up by in 2023 there was a significant change of a restructuring and governance approach, which was another milestone for the center, which have because of the birth of the Court of Arbitration. And with that we in 2024, sorry, and that has been the past 2 years. Significant changes and reforms has taken place in the institutional aspect, and 2025 was also seeing we have launched the new rules introducing the Court of Arbitration, and also many other aspects that we have covered in the new rules to make sure that we cater to the demands of the emerging markets, and of course going back to the UNCITRAL as well. And this is basically in 2025, and we are now going into a 2026. The launch of the rules will certainly be enforced together with some of the amendments that was done to the local legislation as well. All will be enforced at the same time. So we are looking forward for 2026 with a lot of hope and ambition, with the rollout of the new court, as well as to see the new rules to set another stage for the AIAC. And of course, where do we stand today is something that I have explained a while ago. It is a public serving institution with many aspects of ADR, and we can never work together in this. We got a pedigree of 40 over years, and next year we are going to start the road towards 50 years of the center. But again, the potential is great, and we have a lot more to achieve by working together. I mean, being part of 4ACT is one more strategic move to work together with our member institutions from the OIC country, and also being in many other coalitions and networks, and supporting all our partners from this region will be a mandate that we need to do together, both in the Asian African region as well as other parts of the world. And the next is we will look through. Generally, these are the ecosystem of ADR. I believe so some of you are quite familiar in terms of the Arbitration Act that has been recently amended as well. And I think every other time the IAC will be one of those that stakeholders that work very closely with the government if at all there is any amendments required. And not only that, AIAC is also the appointing ad hoc for ad hoc arbitration. We are the appointing authority under the law. And for construction payment, this is a very interesting act. Been there for 1 decade, and AIAC has been playing their role as an appointing authority as well under the this act. This is an interesting local legislation, but having said that, now many countries have taken model upon this, and we record a lot of high number of cases when it comes to construction payment disputes. And this is an area that we are now working with and wanted to work with many other arbitral centers as well, and also other jurisdiction. How can we effectively work on this particular area? And Hong Kong has also have a similar model now I think just come into force. They've amended the act, and some of the arbitral centers has been named as an appointing authority under the local legislation. So while this holds a significant opportunity, this model holds a significant opportunity for many other arbitral centers as well. And we record almost 600 to 700 cases per year when we come to resolving dispute. And we have significantly done quite well in supporting the local construction industry. Mediation Act, of course, it's been there since 2012. AIAC have not recorded a significant number of international mediation, but we have been supporting the mediation and mediators in the country in many aspects. And not to forget, while we are talking today, the government of Malaysia has also tabled the bill. First reading has been done in the parliament in order to rectify the Singapore Convention. Be that we are being a signatory to the Singapore Convention since 2019, and now the government has moved the amendments to rectify, and we hope that everything will goes well in the first quarter of next year. And that holds again another interesting development in the mediation framework for the country next year. And moving ahead, these are some of the key amendments. As I said, that there was an amendment to Arbitration Act in last year, and it's going to be come into force. So whatever we are seeing here are those aspects going to come into force in 1st of January, introducing the inaugural AIC Court of Arbitration. This is important because the AIAC has embarked to introduce the Court of Arbitration. But having said that, it is important also to align with the legislation, because we are the ad hoc appointing authority. So at the moment, the director of AIAC has been named under the Act. So it has now going to be changed to the president of the AIAC Court of Arbitration, and it's already done. Amendments already done. The legislation will come into force on 1st of January. So it is important the legislation align with what has been done, because this is a mandate, trust given to the AIAC, automatic recognition of the arbitral awards, applicable laws by default. This has also been addressed, the law and seat of arbitration for Malaysia, digital electronic signatures, and most importantly, the legislation of the third-party funding, which to enhance further transparency. And before this, Malaysia does not legalize third-party funding for arbitration, and that is important because we have now. And also not to forget that there's a specific guideline will be coming by end of the year. There's going to be the third-party funding, which is going to be the code of practice for the third-party funding ecosystem in 2026. So this is going to be a very new code of practice that's going to in any time soon. We were involved in the various sectors of discussion with the government, and also because this is going to be a code that will be released by the Minister of Law and Institutional Reforms. And it's not mandatory, but it's promoting, of course, certain good aspects of third-party funding. And this is important because we know the debate going on this, and Malaysia going to be supporting, and you know about what has happened in the Sulu case, especially for Malaysia being involved and named in that, and we have come a long way. And of course, the recent decision on 9th of December favoring Malaysia winning the landmark decision was given in favor of Malaysia in that matter. But we have taken a lot of significant steps, especially Malaysia is concerned. Malaysia has taken a lot of significant steps when it comes to third-party funding. So now moving towards supporting third-party funding framework in this country, it is also important to have a code of practice. So this is going to be something unique that we will see soon once the full code is been released by the government, and we were involved in some aspects. These are areas that we have been discussing. I believe so will be covered at large in the third-party funding code of practice, from the requirements of third-party funding agreement to capital adequacy, conflict of interest, control and influence over third-party funders' liability for costs, and of course termination of third-party funding. And I think the government have used a very light touch approach when dealing with third-party funding. And while it is legal, there are code of practice that's going to be put forward as well. But this is going to be encouraging third-party funding, but it's also going to promote ethical and responsible use of the third-party funding in the arbitration. And moving ahead, this is I just want to show this because I believe so that AIAC can work with many other arbitral centers, not only in our region but beyond that, because I think that there's a great potential, because as I said just now, in 2026, apart from the tech industry, apart from the energy, construction will remain as a very significant sector that will see high amount of disputes. So we can work on many areas. This is only one small aspect on payment dispute, but it has been very successful, and I think this is something that we can and ready to work with many other arbitral centers or any other jurisdiction. And if the centers would like to be the appointing authority in their respective jurisdiction, there are many ways that we can actually work together. And this is how AIAC has done. It's just a glance of the cases and how it is. And moving ahead from the CIPA, it's this is the mediation, as I just said, from the rectification, the use of cross-border, we hope. And very important one is also the government. We have just had some discussions with the Cambodian government who came to visit AIAC, and we have also had some of the arbitral centers and government representative from ASEAN member states responding back to what Doctor was saying, how the ASEAN countries is working together, Doctor. After the ASEAN Law Summit as this over, and Malaysia concluding its chairmanship, it has opened a lot of doors for us to work together with ASEAN's countries. Yeah. So we are now working in collaborative. Just 2 weeks ago, we meet with delegations coming from Cambodia, and they are also actively working on a lot of community mediation. They are seeing a huge rise in Cambodia. The government is now working and recording up to 2,000 mediation cases, and we're going to see how areas that we're going to work together. And this Malaysia Mediation Center is something that Malaysia is going to move, because there's going to be a domestic amendments to Domestic Mediation Act next year, and maybe this is going to be introduced as well to support community mediation at large. Sure. I'm going to finish already, Doctor. The next aspect is AIAC in focus. This is very briefly to say that our engagement is just an overview. We are concluding year 2025. This will be continued. The rules are there. It's also available on the website. And next is the next part is these are some of the AIAC dispute resolution products. As you know, that we promote almost the same. And of course, one of the products that I would like to draw your attention is arbitration rules. And I think I spoke about this as well during our conference. Arbitration rules is a very important innovation of the center. And I think OIC countries and regional centers within OIC, we can work together within this framework. Sharia compliance and Sharia guided principle. This is a unique feature of rules that we already have it since 2017, but we have enhanced it further. And these are some of the key features what I'm showing here. And this is also addressed in the rules book. And this is something that I said we can have a framework, needless to mention about model clause, but most importantly a framework for the arbitral centers within OIC, that for us to work together for the 2026 and beyond to promote together this form of framework that complies with the Sharia principles. And AIAC being one of the pioneers in this, we are more than happy to work together in promoting this as well. Next one is these are some of these adjudication rules, which is I'm putting it up because it can be a good reference point for many of our listeners. And nextly, this is our statistics, year 2024, the steady case that we record, of course, mainly coming from construction sector and adjudication. And we are working together, especially on looking into the arbitration which is important aspects, especially international arbitration, while domestic arbitration remain our core business. Nextly, so, Doctor, this is our empanelment. I think it's important to highlight we have a more international compared to national empanelment. Malaysia, in AIAC, we are building. As we speak today, the number is growing and more empanelment applications is coming in. And with a transparent system of empanelment, and I think we have a lot more panelists. And we have from arbitrators, adjudicators, mediators, and DNDR is a very interesting area. I think also for Istanbul, it's a very interesting area for domain name dispute, and AIAC is one of the office together with Hong Kong, China, and also Korea, and Japan going to be the new one to be admitted. We are actually a coalition of arbitral centers working to promote, especially on domain name dispute, and so for us to resolve .com cases, and not forgetting Malaysia is also working for, AIAC is also the authority that resolving on .my disputes. And lastly is our why. This is maybe, Doctor, I have to do this because this is our promotional slide. AIAC is always recognized in GA. I mean, you know the place, you've been here. I would like to welcome our listeners and any partners use AIAC's facilities. It belongs to the world. It is been the place is one of the outside of the Peace Palace. This has been in the floor size. It's one of the highest. Largest floor size, and in terms of the rate is one of the lowest. So we should consider using the place in our region and together. And I think the brilliant building where we are now is been given to advocate and also to promote ADR together. And I think we are opening up the doors for us to promote the ADR together, and AIAC can always come in partnership, be that for event here, be that for hearings to be conducted, for your cases to be held here, if it wishes, as wished by the your own clients and parties. So that is how the building is been serving its purpose now, despite many years, 100 over years building. So this is one of, we have been recognized at this premier hearing center, and we would like to work with many people, especially the center is concerned. So as we concluding my presentation here, Doctor, we can see here I've named some of very interesting centers. The one on the right are all the ALCO centers. I hope that I didn't miss any of my sister centers, and including AIAC, there are actually 6 centers now. And all the rate, if you can see the black ones there, these are some of these centers landscape across our region. We have some coming from, I have YCAC there as well, and I've also named some of these centers in ASEAN sector and some of those in several other sector, those who have a part of POAC as well. Okay. So the opportunities is great for us to work together in many aspects. And
thank you.
That's all. This is just our memorandum, and we continue to work together with many parties.
Absolutely, absolutely.
Yeah. This is our blueprint, Doctor. 2026, and all listeners, and 2026 will be the enforcement, final phase of closing of the restructuring, establishment of the court, our pathway for ODR and CMS, and strengthening the global presence of the AIAC. And that is never without all of you. And this remains as a plan, I dispute resolution initiative. This is what I would like to offer in our discussion today, that this is a game plan that we can work together.
I thank you for this, Danish here. Thank you so much for this excellent presentation. I gave you more time because you're joining from Kuala Lumpur, and I know it's the time is not friendly, and that's why I gave more time to you. And thank you. This is really good. I have so many questions though, and but before then, I would like to congratulate you because I didn't realize I introduced you as as assistant director, or I just got to know that you are now the deputy CEO. So congratulations. I'm sure that's new. We're not aware of that, and I think we wish you more successes, I mean, your professional career.
Thank you so much, Doctor. I think I share your own spirit. Positions are temporary, the agenda will go on.
Absolutely, absolutely. I like that. I've got so many questions, particularly, I'll just ask the question now, but you don't have to answer because I need to move to the next speaker. There's this question of automatic recognition of arbitral awards. So, what is now the role of the courts, and how do we kind of compare that with what you have in the New York Convention, basically? If you want to answer that within 15 seconds, you can do, but I don't want you to.
Maybe we come back to that later, Doctor. We let the.
Absolutely. Okay, great. Excellent. Thank you, Danish, again, and for that presentation. I would now like to, it's far away, we're just kind of taking off from ASEAN region, in particular Kuala Lumpur, flying all the way to West Africa, and we will be inviting Hawa Usman, the Registrar General of the Nigerian Chamber of Commerce Dispute Resolution Center, to share with us her own insights regarding the trends she has seen in Africa, particularly in 2025, and the outlook for 2026. I'm told she'll be speaking on strengthening Africa's cross-border dispute resolution infrastructure, the Nigerian perspective. The floor is yours, madam. You're muted, please. Can you unmute yourself? Okay.
Yeah, thank you very much again for the invitation to speak on this platform. Let me try to share my screen. So I just outlined here some few points. Can I confirm that you can see my screen?
Not yet. I think it's coming up.
Okay.
Or it's taking, you can keep speaking, no problem, while we wait for it to share. You can try to share your screen again, and while you speak, no problem. Okay.
Okay, all right, thank you. So for Nigeria, I think I started with a little background just to show that for arbitration and mediation is not something that is new for us. And I know that over the years, there has been a lot of development. Okay. Just give me a minute to open that document so that I'll be able to share it properly.
Okay. So I know there are a lot of cases involving African investors, even from the ISDS, related cases. Yeah, even at the OICAC, we've got some referrals recently involving some African countries here. Again, whenever you have this post-war kind of crisis, and you have some countries where you've got this military incursion, basically, military coups taking over. There are always cases, and the cases are mostly investor-state disputes because you have expropriated assets and all this. So we've got similar cases referred to us recently, actually. Yeah.
Okay. All right, thank you very much. So I was just looking at it, and I was thinking that apart from even the ISDS cases, now we're going to begin to see even a new wave of cases with the African Continental Free Trade Agreements being a major topic of discussion within Africa, especially even within Nigeria. Can you see my screen now?
Not yet. I'm told you have the co-host access, so you should be able to share.
Okay, share. Okay.
We can see your screen. Just click on share, and you should be able to share. Yes, it's coming up now. Great. And sorry, I'll only give you 10 more minutes from now. So the count starts now here. So take it from there.
Okay, thank you very much. So I was just saying that to share the context and why this is very imperative. That
Can you click on one icon down there so that we can see the presentation mode? There's something that looks like, okay, great, excellent. Go ahead.
So over the years, arbitration and mediation in Nigeria has moved from the pre-colonial and indigenous foundations to colonial period and post-independence developments, like you have rightly mentioned. It has also moved all the way to what we now have as the modern Arbitration and Mediation Act. So why is this conversation important and why does it matter to us now? As you know, Africa is no longer a peripheral player in the global commerce. We have gone a long way, especially in Nigeria. As you have rightly indicated, Nigeria has found itself as a major player in this field. And not only that, Nigeria has, over the years, been either a claimant or a respondent to so many exit cases. I'm trying to remove this icon so that I can have only my screen. Anyway, so the landscape for us, it's to see the big picture. Nigeria alone has been a respondent or claimant in over 30 known investment treaty disputes. The African Continental Free Trade Agreement is projected to increase intra-African trade by over 50% by 2030, according to the World Bank. What this means to us is that we're going to be seeing more disputes, more trade, more disputes, and as the increase in more disputes and more trade means that there is an urgent need for regional dispute infrastructure to be put together. And what this also means to us is that African countries must begin to build a kind of capacity that will put them on the global stage or ensure that there is a standardized model of dispute resolution mechanism as envisaged under the agreements. So for Nigeria, you know, it has moved from what we used to have before the colonial period, then during the colonial period, especially the 1988 Act, which until 2023 was repealed. And with this new act, we now have a major introduction of new areas, new dimensions to make arbitration in Nigeria is global and standardized dispute resolution mechanism. What this means is that our 2023 Arbitration and Mediation Act, especially, has become is a major judicial shift for us from intervention to support. So the idea is to have Nigeria become an internationally recognized dispute resolution hub, whether in terms of arbitration or in terms of mediation. And before 2023, you know, what we have was actually the Arbitration and Conciliation Act. But in order to make this more globalized, the Act has removed what used to be the conciliation part of the Act to now be mediation in order for it to be in tandem with what we have, like the New York Convention and also the Singapore Convention. So what this means for us is that we'll be talking more about arbitration and mediation as a globalized subject than what we used to have as conciliation. So looking at the trend for the disputes that are majorly part of the dispute resolution net in Nigeria or in Africa generally, construction and infrastructure disputes. And I was happy when Marcus mentioned at the beginning that infrastructure and construction disputes are disputes that we're going to be seeing more in 2026. And as such, we must begin to have a shift of our mindset, begin to look at it as problem solving rather than a case for us to just capture and begin to milk in. So a large number of those cases are projects, power projects, roads, and PPP infrastructure projects. And arbitration has increasingly been the preferred over courts due to, like we all know, technical complexity, speed, and confidentiality. So for oil and gas arbitration, the major types of disputes you see are JV agreements, production sharing contracts. And for several of these cases, the seat of these arbitrations have majorly been London and Paris and Singapore also. But increasingly, we're seeing countries like or arbitration centers like the Kigali Arbitration Center, the Lagos Court of International Arbitration, increasingly becoming the go-to places for this dispute resolution. What this means to us is that there is a lot of recognition in local seats with international standards. And that is what the NCC DRC is also trying to do, to place itself in that global recognition as an institution that can provide globally acceptable standard of dispute resolution. And for us, as appointing authority, what we also have is to be able to have arbitrators who can serve on the global landscape. So what this also means is that the institutions and legal framework that we have in Nigeria, which is the Arbitration and Mediation Act, and recently the National Policy on Arbitration and ADR, is positioning Nigeria as a global hub for arbitration. And for us, this is an opportunity for us to take advantage of it, to ensure that the provisions of the Act are things that we entrench within our system. So opportunities for local and international investors is that now we can see that there is a policy momentum in Nigeria. The new national policy signals that there is a government commitment to a reliable ADR environment, which can bolster investment confidence, reduce dispute timelines, and make Nigeria a more attractive seat for regional arbitration. Also, what we also intend to bring to investors is what Marcus has talked about earlier, the issue of speed and neutrality, to ensure that Nigeria acts as a regional gateway to scale markets and to ensure that there is legal talent. Like you said earlier, the Chartered Institute of Arbitrators, the Nigerian Institute of Chartered Arbitrators, and so many ADR institutions are building capacity for Nigerians. A lot of time you're seeing people are becoming fellows of the Chartered Institutes, getting more trained and entrenched in the system. So what do we intend to use with this, to use the legal talents that we are building to do? It is to ensure that Nigeria, or Africa as it were, becomes the global hub to be able to take care of the kind of disputes that will be emerging from these technical issues like we see. And this reminds me of my earlier discussion with Marcus at the OICAC days, to ensure that we have contract administration and management board who can take care of contracts from the beginning till the end, ensuring that disputes that would arise have been taken care of. So we begin to see our clients as business partners rather than just as opportunity to make money or to be in legal business only. So we have to begin to see partnership even as we build and resolve disputes. So it's not just about resolving disputes, but also ensuring that clients or customers are also business partners in ensuring that communities that these projects are trying to serve also benefit from it as quickly as it is possible. So For us, what's the strategic contribution for NCC DRC? Like I mentioned earlier, it is to ensure that there is institutional credibility. Going forward, what we should be thinking about, or what we are already thinking about to do, is how to ensure through these various collaborations that we're trying to build, to ensure that there is institutional credibility, that our transparent panel of appointment is seen to be transparent, and that there is administrative efficiency, because this is also key to any dispute resolution mechanism. It is important that even as arbitrators move forward and ensure that they partner with the clients that they serve, that there is also no administrative bottleneck, that there is administrative efficiency to ensure that disputes are resolved within a reasonable time, which is what the Arbitration and Mediation Act seem to promote.
Yeah.
So positioning the NCC DRC as a business supportive ADR center, and that it is also a relationship preserving center and also cross-border friendly. So this means is that what this means is that the collaboration that we are building with partners outside of Nigeria is to ensure that there is cross-border opportunities for us to align our practices to ensure that we're able to not necessarily put together what we have, but to ensure that we align with other dispute resolutions, not only in Nigeria, but across Africa and also across the OIC countries. That way, there will be a uniform standard. There will be partners or investors within any of these countries will have this reliability as to what is available, and there could be also predictability in terms of the dispute resolution mechanisms available. And also, at the end of the day, there will also be enforceability, predictability, if I may say so. So, yes, to enforce the true test of cross-border ADR centers, arbitration, Nigeria is already a New York Convention signatory. So we intend to see more countries being, I know that during the OIC-AC days, we have talked about a lot of OIC-AC countries that haven't signed the Singapore Convention. So going further, we intend to see that more countries within the OIC-AC countries within Africa are, becoming more responsive to signing the Singapore Convention. That way, most of the countries are on the same global scale to be sure that we can predict not only the ADR mechanisms, but also the enforceability at the end of the day.
Absolutely.
Because yes, it will just be absurd to have a judgment or an award that you cannot enforce just because a particular country has not been able, or where an investor has invested is not a signatory to any of the internationally recognized agreements. So I think one of the things that we should or we would be doing, and this is why the FOAC, OIC-AC and FOAC is important to us, and we see it as a regional multiplier, so that at the end of the day, we're able to harmonize the standards of the ADR mechanisms, and that we're also able to have cross-border institutional cooperation, because without having a standard where to start from, it will be difficult for us to have this institutional cooperation. So it will be good that we are on the same or at the same level at some point in terms of either being all signatories to the conventions. That way we know that this is the standard or this is the minimum that we could have to work with. That way, so, yes.
Okay. I'd like to thank you very much. Do you want to conclude with, I'll give you just to conclude. 1 minute, please. Sorry. Yeah.
Okay, all right. Thank you very much. So I just want to add that for me, I see that there are lessons to learn from the Nigerian experience in terms of the law reform that have taken place within within a couple of years between 2023 to 2024 and 2025, where we have the 2023 Arbitration and Mediation Act, which I feel other African countries that haven't really adopted the new innovations into the act can also look at the act and also see how they can use it as a model, not necessarily exactly, but at least let it be a model for other countries to also follow. So also to see that institutions see, from like what Marcus said, that our clients are more important than just the business that we have to do as lawyers or as uh, ADR, practitioners. So enforcement is the credibility and currency, which is more important at every time, because to get the award is one thing, but to enforce it is another thing entirely. So mediation must be not too strictly structured, but at least let it be flexible enough for people to be able to maneuver and be able to practice and be satisfied at the end of the day. So regional cooperation is what we actually see, whether as Africans countries or as OIC countries.
Thank you so much. Thank you
Thank
so
you
much
very
for
much for the opportunity to speak.
I appreciate that, Hajia Hawa, and I think it's really important to look at the regional cooperation you mentioned, and I think this is what we've started. For me, I see that as a major, major, major move for 2026 for all of us in terms of
Yes.
forward with our reforms. How do we work together as a federation of the OIC arbitration centers with other partners? And the charter we are drafting is almost ready. We're going to share it with the members of FWAC and be prepared. We really want to kind of make that kind of a global, move, hopefully in 2026. And thank you for your thoughts. I saw that Marcus actually, was agreeing with one of your thoughts there in terms of how do we collaborate, how do we see even our clients as business partners rather than just clients, basically. So I think it's really important. You've made some very important points, and I think this complements what Danish has actually presented earlier. Now, I know we do have another presentation or intervention from the from I'll say East Africa. But we'll be coming back to that later. Basically, even though we are currently in Africa, so we'll be moving straight again to Iran. And with us is Dr. Rahima. And Dr. Rahima, I know you'll be focusing on transnational legal approaches to navigating sanctions in international trade. And you'll look at how to balance compliance with contract stability and commercial reality. I think this is quite important. And again, coming from Iran itself, someone who is an Iranian lawyer, who is an expert, who works with an international law firm there. And I think this is really unique. And I'm sure the participants will benefit a lot from your intervention. And I'm really, again, sure that they're going to have a lot of questions for you, definitely. And so I'll allow you to kind of speak for the next 12 minutes and before going to our last speaker for the day. Thank you.
Thank you, dear Omer. It's an honor to contribute to this discussion on the impact of, international sanctions regimes on commercial contracts, especially the international ones, involving Iran as one of the biggest OIC member states. I prefer to have my remarks draw upon both doctrinal analysis and practical experiences in Iran jurisdiction that have been directly affected by complex and evolving sanctions framework. As you mentioned, my topic, which is transnational legal approaches to navigating sanctions in international trade and in balancing compliance, contract stability, and commercial reality, I want to add something that I will continue my remarks about the role of arbitration in these contexts. The role of international arbitration in sanctions-affected commercial relations in an environment increasingly shaped by complex and persistent sanctions regime, international arbitration has emerged as a central mechanism for managing the private law consequences of sanctions. Its role, extends beyond that of a mere dispute resolution forum. Arbitration, plays a role or operates as an institutional intermediary between public regulatory constraints and the logic of private commercial law. I want to first go through the role of sanctions as a structural phenomenon in international commercial contracts, and then I will dive into the arbitration and its role in this context. The sanction regimes cannot no longer be understood merely as temporary instruments of foreign policy. The sanctions has evolved into normative system with quasi-regulatory effects, reshaping the legal architecture of international trade. For many OIC states like Iran, and especially Iran, since Iran is under multi-sanctions both imposed by US and EU, sanctions functions as a persistent external constraints influencing contractual behavior, risk allocation, and access to dispute resolution itself. The unilateral and extraterritorial nature of the sanctions make a challenge and in foundational principles of international economic law, including legal certainty, the neutrality of private commercial relations, even pacta servanda. From a private international law perspective, sanctions generates tensions within contract law. First, they blur the boundary between legal impossibility and economic impracticability, particularly where performance is not formally prohibited but rendered commercially or financially unviable due to banking and compliance barriers. Second, traditional doctrines such as force majeure and hardship often prove insufficient when applied mechanically. Recent arbitral practices demonstrate somehow increased reluctance to automatically excuse non-performance solely on the basis of sanctions, especially where foreseeability or risk allocation can be inferred. Sanctions disproportionately affect long-term and relational contracts, with destabilizing their economic equilibrium and undermining legitimate expectations, an issue of particular relevance in sectors central to OIC economics, such as energy constructions and cross-border investments. One of the most significant lessons from recent practice in the inadequacy of purely domestic legal solutions, national courts, they often are even ill-equipped in addressing transnational complexity of sanctions-related disputes, since they remain anchored in domestic public policy considerations and political imperatives. Moreover, maybe even over-reliance of the law of sanctioning a state risks transforming private commercial disputes into indirect enforcement mechanisms of unilateral sanctions, raising some concerns about a systematic imbalance and maybe legal asymmetry even. Here we want to talk about an idea of transnational law, which is out of any boundaries. Whenever I start speaking about transnational law, I mentioned that this is something much broader than even international law, which is a complexity, which is a context, consists of soft law, international law, lex mercatoria, international principles, And all of them are, the context that transnational law has contributed. Against the backdrop, transnational legal approaches offer a corrective framework by the transnational law by integrating instruments such as unilateral principles, general principles of international commercial law, trade usages, all those things. Parties somehow can construct contractual regimes that are less vulnerable to abrupt legal shocks. That transnational law make a floor or enables, let's say enables the functional interpretation of contractual obligations, and also dynamic adjustment through renegotiation mechanisms, and principled balancing between compliance obligations and contractual stability. In this sense, transnational law does not seek to neutralize sanctions, but to mediate their private law consequences. Now I'm starting to talk about how dispute resolutions can play a pivotal role in sanction-affected contracts. International arbitration, as particularly seated in neutral jurisdiction, offers a forum capable of engaging with both public international law considerations and private realities. Arbitral tribunals are increasingly attentive to good faith and the preservation of contractual purpose. Furthermore, the inclusion of multi-trier dispute resolution clauses reflects a growing recognition of renegotiation and mediation are not division from legal certainty, but or even effective instruments of contractual resilience. The central challenge is reconciling sanction compliance with commercial rationality. As a transnational legal approach reaffirms the tensions by recognizing the compliance as a legal necessity, while resisting its transformative into, how can I say, a tool of maybe automatic contract invalidation. This balance is partially critical for a country like Iran and any other OIC member states which are affected by unilateral sanctions, where access to global market must be preserved despite structural constraints imposed by sanction regimes beyond their control. Through this transnational legal reasoning, sophisticated contract designs, and carefully calibrated dispute resolution strategies, let's say it is possible to manage sanctions-related risks without sacrificing the integrity of international commercial relationships. And these international sanction regimes has profoundly altered the landscape of international trade law, however, they do not render contractual stability, but we have to go after a remedy for this problem. I believe that sanctions are imposed by states, but their legal consequences unfold in the realm of the private law. It is precisely in the space that transnational law demonstrates its greatest value and its great effect on this situation. To start I know I'm out of time. I have only 2 or up to 3 minutes. I just want to a little bit talk about the role of international arbitration in the situation of under sanctions contracts, international commercial contract law. National arbitration allows for a degree of insulation from domestic political, maybe I say, imperative, unlike national courts, which are structurally embedded within the public policy framework of the sanctioning states. Arbitral tribunals, particularly when seated in neutral jurisdiction, a better position to assess sanctions in light of contractual obligations, party autonomy, and principles such as good faith and proportionality. And this is the exact thing that reduce the private commercial disputes and which are transformed into direct enforcement mechanisms for unilateral sanctions. Secondly, arbitration provides a privileged forum for translational legal, maybe I can say reasoning. Arbitral tribunals are more receptive than domestic courts to the application of non-state normative instruments, including the unit law principles, general principles of international commercial law. And thirdly, arbitration plays a crucial role in distinguishing legal impossibilities from economic impracticability. Arbitral practice demonstrates that sanctions do not per se discharge contractual arbitrations. Instead, tribunals examine whether performance has become legally prohibited or merely commercial burdensome due to compliance, banking, or logistical constraints. This distinction is practically relevant in the, let's say, application of force majeure, hardship, and the duties of renegotiate. First is the, as I think, is the procedural flexibility of arbitration, which enables tailored response to sanction-related disruption, multi-trial dispute resolution clauses, temporary suspension of proceeding, and a structured renegotiation or mediation phase reflects somehow growing, developing recognition that preserving the contractual relationship and maybe as important as adjudicating liability. In this sense, exactly, arbitration functions not only as a mechanism of adjudication, but as a tool of contractual violence. And as the fifth and the last, since I'm out of time, I want to mention that while enforcement of arbitral awards in a sanctioned context presents practical challenges, arbitration retains a comparative advantage under the New York Convention when compared to domestic judgments. Increasingly, arbitral tribunals demonstrate sensitivity to enforcement realities by calibrating maybe remedies somehow, let's say, timing of performance and even the form of the relief in manner that mitigates sanction-related obstacles at the execution states, which is, I think, the most important part of the arbitration tribunal, the performing of their work. And at the end, as a conclusion, I want to international arbitration in a sanction-affected environment should not be viewed as a means of neutralizing the sanctions, but I think is a technology of legal technology, let's say, legal technology which rationalize the private law effect. For countries like Iran facing a structural and long-term sanction exposure, arbitration offers a framework that preserves contractual integrity, mitigates legal asymmetry, and sustains access to international commerce despite constraints imposed beyond parties' control. So I want to end it up since I'm out of time and I set an alarm for time and I want to
absolutely
take it. And thank you for it and your attention, and thank you for this platform and to give me the chance to speak as a representative from a country named Iran, which is under unilateral sanctions about 47 years. And we have a lot of things to say, especially in the arbitration, access to arbitration itself. I wish we could have more of these chances in order to represent this. Thank you, Omar, and distinguished participants. It's so pleasure for me to be at this session.
Thank you so much, Rahima, and really thank you for this perspective. I have one quick question, and you have just 30 seconds to answer that question. Because it's really kind of relevant and it's practical. The question is this: many Western courts now view compliance with their own sanctions, as you rightly said just now, as a matter of international public policy. So you have to comply with their sanctions they are imposing on Iran. And if you don't impose, then you're violating public policy. Now, how do you draft arbitration clauses to ensure that a future award is not rendered unenforceable on public policy grounds? Are you increasingly opting for seats like Oman? I saw you in Oman recently, Qatar, or Singapore, to avoid the risk of a European or US court setting the award aside. What do you have to say about that?
Would you please explain more? You mean that in order to make these contracts work, what we do, or about the arbitral award, which one of them
You
you mean?
select a seat that is not actually based in Europe or in the US,
Yeah.
such as Oman,
You know,
Qatar, or Singapore. Is this something you're doing at the moment?
yes. First, preference of any Iranian company or corporation who are engaged in international commercial contracts is first Dubai, then Oman, and then Turkey. We
Okay.
do not go much more far from away to the eastern part of Asia, but somehow, since we have the biggest turnover of exchange with China,
Yeah.
but we have rare, connection with the seat of arbitration in
Got it.
Eastern Asia. The
Okay.
preference is in Turkey, Oman, and
Okay.
United Arab Emirates much more
Okay.
than
Okay.
Eastern
Thank
Asia.
you. Thank you for that. I'm sure Danish will also say you should choose Malaysia. Okay.
Yeah,
Okay.
we
Now,
will, we will. We are going to do.
yeah, yeah.
You
Okay.
hear me, doctor? You hear me?
How we say no, Nigeria is better. Okay. Yeah, that's what they call country
And
competition.
the added value of OICAC, Arbitration Center of the OIC, is
Yeah.
that when we have a great turnover of commercial contracts with China, Turkey, Iraq, Oman, and,
Yeah.
and a lot with Iraq. Then
Absolutely.
when,
Yeah.
when we introduce and when I talk about OICAC to my clients, even
Yeah.
domestic ones who are engaged in somehow
Oh,
international commercial contracts, I say
yeah.
that this is the best choice. I'm the
Absolutely.
representative of
I appreciate that.
OICAC. I'm
Thank you for that.
really,
Thank you for that. Yeah.
some of us maybe are the
Yeah,
states
Rahima, we're out of time.
OIC.
Yeah, I'm afraid. Yeah, thank you very much, and thank you for promoting the OICAC in your region and the country there. I appreciate it a lot. If you don't mind, I'll quickly move to our other speaker for today. She's actually the last but not the least, and that's Zubaida. Zubaida, actually, of course, I've introduced her earlier as a CEO of the Muslim Arbitration and Mediation Center. And she's been doing a lot locally. She's, a main speaker in, in most of the events you have there in Uganda and in the region, basically. And thank you, Zobeida, for joining us. I know you've been on the roll since morning, and even with that, you are able to join us here today. And I understand you'll be speaking briefly on the alternative dispute resolution landscape of Uganda, looking at the 2025 review and the outlook for 2026. And before you proceed, I would like to seek the indulgence of our participants that we're supposed to end this whole session at the top of the hour in the next 5 minutes, but I'll seek your indulgence to extend for another 15 minutes so that we can listen to Zubaida and we can also take a few questions. And thank you, Marcus. I see that you've started answering some questions, so that actually helps a lot, to save time. And Zubaida, the floor is yours. You have 10 minutes. Zubaida, are you with us? All right, it seems she's no longer here with us. Okay, we can, while we wait for her, we can start taking questions. If you have any question, please let's know. I actually have seen a lot of questions, and I think Marcus actually has spent really a very good time answering those questions. We've received some comments as well, and thank you, Riham Hussein Anis. We appreciate your comments. We appreciate sharing your expertise with us. She's an Egyptian arbitrator, and with over 25 years experience. We encourage others to also ask questions. I can recognize some people on the screen here. I see Larry and Tony joining us from Texas, if I'm not mistaken. He's also the co-founder of an arbitration center there, from the US. And Zubaida, are you back here with us, please? The floor is yours. Now you have 7 minutes.
Thank you very much, Dr. Oseni, and I'm so sorry. I'm so sorry for the connectivity. I've traveled to a very rural area. Yeah, but I had to make it here. I'm so happy to be here. Thank you very much. And I am honored to be among these very, very knowledgeable panelists.
Thank you so much for your input. And I'm so glad I came in last. The Muslim Arbitration and Mediation Center Uganda just celebrated 1 year on 9th December. So I don't think there's any institution that is going to gain more from the folk than the Muslim Arbitration and Mediation Center Uganda. So thank you very much. When it comes to Uganda, we have quite a young ADR society, really. And yes, we are signatories to the ANCITRO. We've had an Arbitration and Conciliation Act since 2000. And yeah, that led to the establishment of the Center for Arbitration and Dispute Resolution in Uganda, which was abolished last year when the amendment of the Arbitration and Conciliation Act came into force on 23rd December last year. So the vehicle that has been carrying arbitration, like in terms of the national vehicle, was now moved to the Ministry of Justice and Constitutional Affairs. And of course, that leads to questions about independence and impartiality. If you have parties that are dealing with a government entity, how is that going to work? The argument, of course, on the part of government is that we wanted to promote efficiency and effectiveness. Well, that might work for domestic ADR, but it does not look very good for the international space. However, the beauty about it is that there is an opportunity. We have ICAMEC, which is the International Center for Arbitration and Mediation in Kampala, which is a private entity, but it has really taken up the space, and it has an appointing instrument from the government, and it's really doing the job. When it comes to the general contracts that are coming in, we have a lot of the uptake for Islamic finance is really good, and I think this collaboration with the OICSC is quite timely because it's going to help in capacity building. The will is there, but we don't have the capacity. In fact, recently I was having a conversation, and I had this conversation with you, Dr. Seni, with the General Counsel of the Bank of Uganda, and she was actually intimating to me that they are having challenges rolling out Islamic finance products because they do not have the capacity to do it. Like they are trying, and they've done consultancies with many organizations, but there is a problem. And
when we are here for them.
Yes, that is the beauty of this whole thing. Yes, so we are, and I told her, of course, this is the end of the year, but next year this is something that we want to take up so that we can build capacity and also help them navigate the challenges that are within that space. Regarding mediation, we have slow mediation. We've had mediation since 2013, but it's mostly quota next in Uganda. And when it comes to private mediation, I can say I am one of the people who are championing private mediation. And yes, Uganda is a signatory to Singapore Convention, but we want to push for more so that we can have ratification, so that we can also attract those transactions and contracts that involve mediation on an international scale, cross-border scale. The construction, Marcus, he's a Ugandan. He's a Ugandan. Yes, we are like construction. The construction industry is also growing. It's picking up. I think we've started being very, very intentional about construction about 5 years ago. And so it's the same as Islamic finance, a little better, but we are building capacity. We have a construction law institute, but of course we need more from those people who have practiced out of the country. Out of Uganda, the experiences, because, if you're going to deal with cross-border disputes, having just the homegrown practitioners is not going to be attractive enough for these contracts. And yet we have a lot of projects that are going on. Road construction, we have construction also in the oil and gas sector. We have a very booming oil and gas sector. We are rich, Nigeria. We are also rich in oil. So hopefully we are going to find more oil than you. Yeah, but we have such growing industries in the space of construction, in the spaces of oil and gas, but the same thing keeps on coming up. We have a problem of capacity. Recently, at the Chartered Institute of Arbitrators Uganda chapter inaugural conference, the Attorney General was complaining about the challenges that being faced in the arbitration space. And I think it is something that Mark has also mentioned. It is becoming senselessly expensive. And also in terms of time, because arbitrations, when people come to arbitration, they seek to get a solution that is timely, like they don't want to waste a lot of time. So there's this heritage case that has been in the pipeline for about 8 years, and it just does not make sense. And with it, it is taking a lot of money. And for most of our disputes, the seat is supposed to be in London. I don't know if we don't have seats that can actually make, because of course, every time the seat is so far away from where the dispute is, that shoots up the cost of dispute resolution, and like it just makes it so senseless. And it also becomes so distant from Ugandans, so that we don't know what is going on. So there are concerns from the government and from the practitioners as well. Then I like that the fork is opening up spaces for many practitioners in the Ugandan space, because of course you would like to tap into the international space, but without collaborations, meaningful collaborations, it's hard for you to tap into these international spaces and getting the appointments that you seek. So I guess this is a beautiful platform, because within the different interactions and collaborations, we can open it up for Ugandan practitioners who are also very well, they are knowledgeable, and yeah, they're also willing to learn and gain more experience from these international practices. The other thing is the Ugandan courts, and this is a positive thing about 2025. The Ugandan courts have really, really thrown their weight behind arbitration, and they've, like in many cases, including the Simba Group's versus Vantage, the Vantage cases, where Simba Group is a Ugandan organization that had borrowed money and defaulted. And the arbitration, of course, took place in London, and there were challenges there. When they came back to enforce, they wanted to, Vantage applied for a remedy that is not provided for in our Arbitration Act, because our Arbitration Act, Section 6, provides for interim remedies before and during arbitration. Now, here the question was, like, before enforcement, we are seeking a remedy to ensure that the status quo is maintained, in order for us to ensure that arbitration will gain the fruits of arbitration. And of course, there was a debate there, because it's not provided for by the law, but the court invoked Section 98, which is our civil procedure, Section 98 of our Civil Procedure Act, inherent powers to provide that remedy. And in a way, it exposed the gap that is there, because if you are going to promote arbitration and promote Uganda as a favorable seat, you need people who are engaging in arbitration need to know that there's predictability and there's finality. So with the need to promote the predictability and finality, this decision, yes, it was rare. It was, the remedy is not provided for, but I think it is a call to action for the government to work towards amending the law in order to provide for this new remedy, because it is a much needed remedy for you to realize the fruits of arbitration. The other thing is that we have a national ADR policy, which was approved in February 2025. And this shows government's commitment to promote alternative dispute resolution. And we have conciliation, arbitration, all these are being considered. and it is still in the works, like many, how it is going to be rolled out and enforced is still something that is yet to be seen, but at least we have the commitment on the part of government to push out, to throw its weight behind arbitration, conciliation, mediation. And yes, I think right now, as I speak, I feel like it is quite a promising environment in Uganda. And I would invite all of you. Marcus is already Ugandan. He loves Uganda. Dr. Oseni has been to Uganda. I would like to invite Hawa, Dr. Rahi, Dr. Rahi, Ganesh. You should all come to Uganda because we are cultivating we are cultivating a good environment for us to promote arbitration in the space. Thank you very much.
Thank you, Zubaida. That's great. One quick question. What do you see in 2026 in terms of the outlook? Do you see the government promoting ADR? Do you see, people getting to learn more about arbitration? Because I understand it's still new there. We can't be comparing Uganda and Malaysia. Malaysia is far away, and it's actually part of why we established this federation of the OIC arbitration centers. You've got some of the arbitration centers that are highly developed, they have that capacity. They can handhold others, that's the way we work together and we achieve together. And that was how the whole idea actually came about. So what do you think, in 1 minute, what do you think, what do you hope to see in 2026?
Like I said, there's big promise. We have a lot of practitioners. Initially we thought litigation was the only way to lawyer. But now we have a lot of practitioners who want to cross over or who want to also incorporate it in their toolbox as lawyers, to have arbitration as also a service that they provide. We also have, I feel like we have the fact that we are taking up Islamic finance. That also provides another avenue for us to promote arbitration. And so the promise is there. We just need capacity. We just need the support. And I feel like this is the most beautiful platform for us to engage in and to have all the help that we need. Thank you very much.
Thank you very much, Zubaida, for that excellent intervention. And I'd like to invite participants to ask questions. I'm spotlighting all the panelists. So the back end, you've got to take photos of the panelists together. Tolga, Marvi, and Cole, please ensure that we have the photos, the good photos of the panelists. Particularly, you must capture Danish smile, which is really unique. Thank you, everybody. Now let's. Okay. Who is muting me? Okay, let's take some questions. Let me see, do we have more questions that we need to respond to? Okay, there's a question here from Justice Muawi or Baba Idris, retired. He's a very good friend. He's an expert in Islamic finance, a retired judge. He's saying regarding the cost and time of arbitration, his comment is, he thinks the judiciary in Nigeria can't complain about the length of time when they have cases that stay in court for decades. He said he was on the bench of the Federal Capital Territory High Court for 9 years, and he left some cases that he started after his appointment. And as at the time he retired, he said the claimants could not conclude their presentations. He also says he's involved in arbitration before his appointment and after retirement, basically. Generally, according to him, delays in arbitration are a result of lawyers who try to frustrate the process. I quite agree with this. The problem here is you have lawyers who are so active in litigations, basically. Now they are also involved in arbitration as party representatives. So that's why you see all those technicalities actually come into play. Do you know how to overcome these, fellow arbitrators? I know all of you, you're aware of this. You have to make use of your powers. Your PO basically is very important, basically. Your procedural orders. And your PO1 is extremely important. Your procedural order one, set the timetable, set the number of even, witness statements, witnesses to be produced. If you want to go for hot tubbing, set all the rules from day one. And I think that's what I will do. And I've done that in a few cases. You just have to set the rules from day one. And with that, you can control these lawyers. as much as possible. I agree perfectly with Justice Mwawi on this point. Lawyers do actually try to frustrate the process. Unfortunately, we are lawyers. I mean, we are blaming ourselves in a way. But I think we have to actually ensure that arbitration is different from litigation. The process has to be streamlined. It has to be cost effective, and it has to achieve the result it is meant to achieve at the end of the day. Are any comment from colleagues on that point?
Yes, thank you, sir. Yeah, I totally agree with what Justice Moawia has said, and I totally also agree with you. And I think that's why it is important that for people who are in active practice of ADR, we continue to do the advocacy out there. There is need to have a mindset shift from lawyers. They have to understand, and that's why the point that Marcus made that I also reiterated initially is very important, that we begin to see them customers or clients who come to us as ADR practitioners, as business partners. I mean, for business,
I don't know. I can't hear anything from my side. You talked about, I'll take it from there. I think she's frozen. She said we should take them as business partners rather than just clients, you know. So I'm just taking it from here. I hope I can read her mind. Yeah, from here. So I think this is the point she made earlier, and it's extremely important to see them as partners in progress, basically, going forward. Any other comment on that point before we leave? I don't have more questions here, so I'm ready to end the webinar in the next 1 to 2 minutes. But any final comments, takeaway? Marcus, Danish, Zubaida, Rahima, do you want me to go around the screen? I'm going to give you just 1 minute each. Just one. Danish, go ahead.
Doctor, I just would like to, I was just referring back to the question that you posted to me earlier, and I would like to bring you to the amendment that was done in the Arbitration Act recently to Section 38, where we have now have an automatic recognition for the award. So this will be enforced on the 1st of January, whereby the court's role is more for enforcement, for application for enforcement, while recognition will be an automatic, in line with the ANSI trial. So this was a recent development, part and parcel of the amendments in the Arbitration Act, and we welcome those amendments that was brought forward by the government, and I think it will again help Malaysia to be positioned as a safe seat. And with that, Doctor, that while responding to that, my concluding remarks is, of course, I think it's important for all of us to look into areas, common areas that we can work together with FOAC being an umbrella now, with bringing us together. And I think we should look at capitalizing our equal strength.
Sure.
And I think that would bring us a lot of value, and how the OIC arbitral centers can work on many other ways. And if we can result in doing even like what I believe so we discussed, some of the joint rules and joint protocols among certain centers, because we are in various jurisdiction, and we can, if there's two center, if we have now a Hong Kong center and also Uzbekistan center can work together in joint protocols, and I think there are a lot of opportunities ahead of us. And I think this is where we can specifically, not only partnership, I take with what remarks made just now, let's work on a smart partnerships.
Absolutely. That's the phrase, smart partnership. Yeah, we use that a lot, and thank you for that. Thank you, Danny.
Thank you very much, Doc.
Yeah, thank you.
Thank you for the opportunity and having us.
Absolutely. Marcus, the final thoughts, 40 seconds for you.
We are servants. We need to serve commerce, because that's where our value is.
Excellent. You saved my time today. We're servants, and we need to serve commoners. That's where our value is. Thank you so much. And I'm going to go to Dr. Rahima. Final thoughts, 30 seconds for you.
I just want to extend my great gratitude for this session. It was a great pleasure to accompany you and dear distinguished panelists. And thank you so much. I wish to see you in such these panels again and again.
Thank you so much. Hope to see you in Iran soon.
Hope to see you.
Okay, you're Zubaida. Final thoughts?
Thank you so much again. Yes, thank you so much again, Dr. Oseni, for bringing this together. It is quite timely. And I will speak for Uganda, we stand to, I don't think anyone here stands to benefit more. I've said it before and I'll say it again. And for me, because it is capacity, Uganda needs to build capacity, and we are willing to tap into this space to gain as much capacity as possible. Thank you.
Excellent. Thank you so much. Of course, you have the AIAC there. They've been there. They've done a lot. So I'm sure you're going to have a lot to learn from them. And of course, we are here. We'll be very happy to collaborate with you. And I think on a final note, we'll still give the last 30 seconds to Ms. Hawar Usman. She just rejoined. If you're there, please, your final thoughts.
Okay, thank you very much. For some reason, my network decided to log me out. So I think it's just to make my final, the final point I was trying to make earlier, that we just have to continue to advocate that ADR processes, especially mediation and arbitration, are supposed to be avenues for impartial tribunal to resolve cases fairly without unnecessary delay and expense. And this is the point that we must keep pushing for our other colleagues who haven't understood, who have the mindset to see every case as an opportunity for a delay tactic, to continue to understand that the basis for all these other mechanisms is to provide alternative for efficiency and effectiveness. Thank you.
Absolutely. Yeah, I like that. Providing alternative mechanism for efficiency and effectiveness. And I think this is beautiful. I would like to thank you on behalf of the OICAC, for joining us here today. The panelists, thank you for your time. Thank you for your insights. And we look forward to collaborating more. The FOAC initiative, it's live. And we are working behind the scene to finalize the draft charter, which we'll be sharing with all of you shortly. Again, I want to thank the audience, the participants. Thank you for joining us. Thank you for your questions. Thank you for your comments. And it's been a wonderful year for all of us. I'm really glad that we did this together. From 1st of January till here, December, we were actually live. Every month we're live with our monthly webinars. And without you, we cannot do it. So thank you so much. And we look forward to seeing you in the new year. Of course, we'll continue as expected during the new year. We've got a lot of initiatives coming up. So watch out the space. Of course, also watch out the space of our partners, AIAC, the MAMAC. We talk about, also the Nigerian Dispute Resolution Center. Of course, JPAD is always there in Iran. If you need a partner in Iran, JPAD will be very happy to connect with you. Dr. Rahima is a funding partner. And of course, we are all here. Marcos is there. He represents the Marco Partnership, and he's doing a lot. If you need any construction lawyer, an arbitrator, an adjudicator, he's always there to help, to give advice. Once again, I'd like to thank you all for your attention, for your participation, and hope to see you in the new year. Take care, everybody. Bye-bye.
Thank you very much.
Thank you, Doctor. Thank you, everyone. Happy New Year.
Yeah, thank you.
Thank you. Welcome to Malaysia.
Thank you. We're coming. Trust me.
Happy New Year.
Bye-bye.